Hello everyone, and welcome to our lecture recording for Chapter 2, which will cover the origins of Australian law. Our first objective is to explain the factors leading to English settlement and the application of the doctrine of reception in Australia. Now, the factors leading to English settlement take us back to 18th century Britain and the beginnings of the Industrial Revolution. And the change from an agrarian economy to an industrial economy meant that many people became landless and had to move to the cities to find work. This in turn led to crime and an escalation of criminal activity that brought in legislation by Parliament in Britain, such as the Wealth and Black Act of 1723, and this created a menu of capital punishments or capital punishment for a menu of crimes, what's known as the Bloody Act, the Bloody Code. These included things even such as petty theft or arson. As the number of convicted people became unmanageable, the British government took the option of sending them overseas to what was known as convict colonies or penal colonies. So instead of being put to death, they were removed from the country. So between 1770 and 1830, there were roughly around 35,000 people who were sentenced to death in England, Scotland, Wales and Ireland. Okay. But only 7,000 were ultimately executed. Okay. So these death sentences then were basically being commuted to transportation. So they became simply cheap labor for the colonies. The first destination for these convicts was the United States of America. However, of course, following the American War of Independence in 1783, England or Britain was not able anymore to send convicts to America. So the next destination was New South Wales in Australia. So starting from the 1770s, they started sending through these convicts to Australia, and that was really the beginning of the factors that led to settlement of this continent. Second part of our first objective is about the application of what's known as the doctrine of reception in Australia. Okay. And the idea of the doctrine of reception, which is a doctrine in international law, was that if there were lands that were unsettled, what's known as a terra nullius in Latin. So that's really legal fiction, and if you want to know more about these concepts, you can either consult the glossary part in your textbook or go to the Australian Legal Dictionary, which is available online through the University of Southern Queensland's library online. And terra nullius basically means that the territory belongs to no one. So if the territory belongs to no one, the doctrine of reception means that British settlers under international law could take their own law with them to that terra nullius. Okay? So if Australia was terra nullius, if Australia were terra nullius, then the British settlers would simply bring their English law with them or British law with them, and that becomes the law of the land. Okay? Now this doctrine was established, okay, as early as 1608, okay, in English law, to the fact that English people can take their law with them when they entered a new territory, i.e. a terra nullius, or a territory that was unoccupied. Later, in the 19th century, the Privy Council modified this principle because they said that terra nullius could also be applied to territories where the inhabitants had not created an organized society with a recognizable legal system. So the doctrine of reception and terra nullius that the doctrine was built on, so there are both doctrines. There's the doctrine of terra nullius and there's the doctrine of reception. And again, doctrines, we mean by doctrines legal principles that were developed through the court system. So we're looking at how terra nullius was developed through the court system, the English court system or the British court system, and you see that it started from a proposition that you can take your English or British law with you to a new territory if it's unoccupied. But back then there were not that many territories that were unoccupied. So what happened is that by the 19th century, this doctrine was modified to say that by unoccupied we mean unoccupied by an organized society. So the benchmark was basically European societies or industrialized societies. So if there were no industrialized societies, then that land is considered legally as unoccupied. So for legal purposes it's terra nullius, and hence we can take our own legal system and basically graft it into that land. Okay. And the case that said that was Cooper and Stewart, and you find its reference on page 22 of your course book. Alright. The second objective to get us to Mabo, which you see on this slide, talks about discussing the development of Australian law. So we said that the origins of our Australian law started with bringing 750 convicts to the Botany Bay on the 18th of January 1788. Okay, and then there was Captain Arthur Phillip realized that Botany Bay was unsuitable. Okay, so they moved a few kilometers north to Port Jackson, which was on the 26th of January, and that of course became what we celebrate today as Australia Day. Then we come to the development of native law. Okay. So we talked about the doctrine of reception and what that meant. So now we know that when the convicts came to Australia, they brought with them their legal system, and hence the legal system of the land became the English legal system. So another note on Cooper and Stewart, which was a case concerning the validity of a land grant, okay, made by Governor Brisbane to a settler in 1823, and the Privy Council, as we said, had to consider whether the land grant was valid and whether British law applied to it, and they found yes on both questions. Then we come to a case called Milirrpum, or the Gove Land Rights case, also on page 22. Okay. This case was brought on behalf of the Yolngu people, the traditional owners of the Gove Peninsula in Arnhem Land. And this case was brought against the federal government because the federal government granted a mining lease, and the judge in this case, Justice Blackburn in the Supreme Court of the Northern Territory, ruled for the government because he was bound, because of the hierarchy of courts that decides precedents. He was bound by the decision in Cooper and Stewart, which was of course from the Privy Council, and at that time the Privy Council was the highest court in land, the highest court of Australia, although it was in Britain. But Blackburn was sitting in a court in the Northern Territory, and he was bound by that precedent, so he had to say that the grant by the government was valid and that the British law applied to it. And that's the key point for our purposes, that the British law applied. So he was basically saying that the doctrine of reception applied, although in Milirrpum Blackburn found that there was evidence to the fact that the Aboriginals, i.e. the Yolngu people in this case, had a set of sophisticated social customs and rules which could be recognized as a system of law. So in Milirrpum the court found that yes, Aboriginal people did have a sophisticated social system, which says what basically in relation to the doctrine of terra nullius. If we read between the lines, that means that the terra nullius doctrine wouldn't apply. Okay, because they found that there was in fact an organized society with a recognizable legal system, but because of the doctrine of precedent in Milirrpum, the court couldn't come out and say basically that Australia was not a terra nullius for the purposes of the doctrine of reception. That had to wait. So Milirrpum was in 1971. Now we move on to 1992 with the case of Mabo, and this is Mabo number 2. And there was a first case because the government intervened by passing certain legislation, and the people who brought this cause of action had to go and challenge that piece of legislation before they move forward on the question of their ownership of their land of the Murray Islands in the Torres Strait. Okay. In Mabo, the court was very clear now. This is the High Court of Australia, because by then the High Court of Australia had replaced the Privy Council as the highest court in the land. And the issue was exactly the same as in Milirrpum. Was Australia a territory acquired by treaty or conquest, or territory that was terra nullius? So they had two options. You either conquer the land, and that makes you bring your law with you, or but even then, when you conquer the land, the law really is not necessarily going to be the law of the conqueror. So there are two options again. The first option is that it was conquered, and the second option is that it was terra nullius. The court was asked, which of these does Australia belong to? So if the Australian colonies were said to have been acquired by settlement, i.e. based on the doctrine of terra nullius, and the Aboriginals were not an organized society, then of course the law of the land is going to be the British or the English law. If it were acquired by conquest, then the laws of the original inhabitants would be recognized, but always subject to the right of the English Parliament to override local laws. So those were the two options. What did the court say in Mabo? So they came out and said Australia at the time of English settlement was not terra nullius. This is exactly what they wanted to say in Milarpum, but were bound by the doctrine of precedent, so they couldn't say explicitly that Australia is not a terra nullius. That had to wait until Mabo, when the highest court in the land looked at this case and said, yes, in fact, it is a terra nullius, which in this sense was overruling the previous position adopted by the Privy Council in cases such as Cooper and Stewart. So now they are saying it is not a terra nullius, so they overruled the decision of Blackburn and Milarpum, who was simply, of course, following the decisions that were brought by the Privy Council in Cooper and Stewart. Okay. So that brings us to the concept of native title. What do we mean by native title? So now we know that if Australia was not terra nullius, then there would be still, it's just like saying that we recognize that there was an organized Aboriginal society with a recognizable legal system. And it's that recognizable Aboriginal legal system that gave effect, or that created ownership rights in certain areas of land, and that right created pre-settlement that we now refer to as the native title. So native title is nothing more than a pre-existing right that evolved over thousands of years and is not a grant or right created by governments. Okay. Mabo is also important for the purposes of the issue of the standing of precedent and the question of certainty in the law. And if you recall, we discussed these in previous lectures, and specifically in the previous lecture on chapter 1, when we said that certainty is one of the characteristics that we want to have in our legal systems. The proposition that came from Mabo and the fact that they said that Australia is not a terra nullius, after almost 200 years of saying that it was, is this proposition that in exceptional cases the High Court will be prepared to change the common law. In exceptional cases, the High Court will be prepared to change the common law. So the summary of this is that the High Court said that the doctrine of terra nullius does not apply anymore. However, the doctrine of reception was a historical fact. So we cannot go back and say, oh, because the terra nullius doctrine doesn't apply, then that also means that the doctrine of reception doesn't apply, and that also means that the English law does not apply. By 1992, English law has already been received. Okay, it has already been incorporated and became the starting point for the evolution of our own legal system in Australia. So that's now historical fact. The decision by the High Court will not change that historical fact. It can only change the really theoretical principle of terra nullius on which that historical fact took place. But it doesn't change the fact that we now have the Australian legal system, and that the Australian legal system evolved from the reception of English law in the 18th century. Okay. Then we want to know if this decision in Mabo had any other implications. Because later on, in a case called Walker and New South Wales from 1994, so 2 years after Mabo number 2, okay, they wanted to know whether there could also be recognition not only of rights to land, but also of Aboriginal customary law in criminal cases. Okay. So as we said, we finally recognized that in Australia there was an Aboriginal organized society, and that they had a legal system, and that legal system was a sophisticated legal system in the sense that they also had criminal law as part of their legal system. So that's why we call it Aboriginal customary criminal law. And they wanted to know in Walker whether that, of course, would also be possible to recognize in Australia. Okay. The Chief Justice of the High Court, Chief Justice Mason, found that even if the customary criminal law had survived English settlement, it had been extinguished. So the customary or Aboriginal criminal law had been extinguished by the criminal legislation passed by the states and territories. The exciting question here really is the following. Does being extinguished mean that it has been ended, in the sense that it cannot be resurrected? Or is it possible for this Aboriginal customary law to become the law of the land if, again, there is legislation to that effect? Okay, so the body of knowledge that we call Aboriginal customary law might still be available for certain interventions in the future, and we see a very clear example of that in what happened across the Tasman in New Zealand, where the Maori customary criminal law, especially in relation to sentencing, became an inspiration and a source of law for the New Zealand Parliament in certain aspects of the legislation. Okay, we'll leave it there. So we've already discussed really the development of the Australian law, and we can move on now to talk about the developments beyond the doctrine of terra nullius and beyond the doctrine of reception. So now we have received English law, and we want to see how that occurred through these statutes or through these legislative instruments. Okay. So the starting point was with a Charter of Justice, what were called Charters of Justice. There were 3 of these, and they are basically letters patent. Okay, letters patent is a term that you'll find highlighted in red in your textbook, which means you can go and read more about in your glossary part. And this charter, the first one in 1787, established the penal colony of New South Wales and it was the authority for the establishment of the court system. So the first thing we did was not to establish parliament, it was to establish a court system. But how would the court system apply or work if there's no law in the land? So you had to receive or incorporate or adopt the English law, which would be then administered or dispensed by these courts. And these courts that were established by the first Charter of Justice had both criminal and civil jurisdiction. And by now we know that criminal jurisdiction means that these are the things that the state brings as cause of action against individuals, and the civil is where individuals bring causes of action against each other. Individuals in the sense of legal persons, i.e. including things like corporations. Then we see the New South Wales Act of 1787, and this started or was the nucleus for the legal system in the New South Wales colony. So there was a civil jurisdiction, there was a court of civil jurisdiction, and the first criminal court. Okay. And the key point behind this act, New South Wales Act of 1787, was to ensure that English law and not martial law was to apply to the convict colony, and that should be from the first day that the first fleet landed in 1788. Okay, although as it says in your textbook, okay, the governor had almost absolute power at this time. So although the act explained that the law of the land is going to be the English law, in reality it was really martial law, because all of the powers were with the governor. What do we mean all the powers were with the governor? Well, we mean that there were no democratic institutions such as parliaments. Okay, so the decisions were all made by the governor. There was no representative government nor responsible government, and we'll talk about these other principles or doctrines in a minute. Then we move on to the second Charter of Justice. Okay, this one abolished the Court of Civil Jurisdiction and it laid the judicial foundations for Tasmania, what was known back then as Van Diemen's Land. Okay. Once it abolished the Court of Civil Jurisdiction, this charter established 3 new civil courts in its place. So now we have, instead of 1 court, there are 3. There are Supreme Court of Civil Jurisdiction. Okay, this was a court of record. If you want to know more about what that means, you can go to page 54 of your textbook, which basically means that the court had reports coming out of it. So there was the possibility of precedence looking at those records, although of course in the hierarchy of things at that point we still had our most of our precedents being decided in Britain. So there was a Supreme Court of Civil Jurisdiction. Okay. There was the Governor's Court, and there was the Lieutenant Governor's Court. 3 courts instead of the one that was abolished. So this really was the first time that we start to see a modification of the governor's absolute power. Okay. So now you have the Governor's Court, which could only deal with the recovery of small debts, and the Lieutenant Governor's Court, which could only deal with civil matters up to a certain monetary amount in Tasmania. And then you had the Supreme Court. Okay. And that Supreme Court then became a check, if you like, checks and balances in a way on the governor's absolute power. That would come, of course, through the Governor's Court. which was New South Wales, of course. Let's then go to the third Charter of Justice, and this is the charter that led to the New South Wales Act of 1823. So this is the second New South Wales Act, and this was the act that finally established New South Wales as a full colony. Remember, the first act established it as a penal colony, and now the Act of 1823 establishes it as a full colony. Okay, what did that mean, full colony? So now the colony had Supreme Court with civil and criminal jurisdiction. Okay, it had a legislative council. So slowly now we're starting to introduce democratic sort of instruments, although of course this legislative council was simply advisory to the governor. Okay, so we didn't still have the representative government coming in. By 1828 we see the Australian Courts Act, and this is the first time we see a limited self-government given to the colony of New South Wales, and this was the beginning of the evolution of a legal system that has a distinctively Australian characteristic, in the sense that all laws in force in England were applied at the beginning in Australia as far as was reasonably consistent with local conditions. So now, which is what we mean by evolution, now we've allowed for local conditions to vary the English law that we have received, again back through the doctrine of reception. This act also expanded the size of the Legislative Council, and it marked the beginnings of a move towards responsible government. Okay, you want to know more about responsible government? Again, a good place to start is the Australian Law Dictionary, and basically responsible government means that the government is responsible to this Legislative Council. So the Legislative Council can carry out the function of accountability to make sure that the government is doing what it's intended to do, and to make sure that the government is adhering to the laws or to the mandates given to it. Okay? And of course this Act of 1828 stipulated that English statutes passed after this year, i.e. 1828, apply to Australia only if there were particular provisions contained in them to that effect. So no more are we going to receive English law the way we did from 1788. Now English law is received in Australia only if that English law was made specifically for Australia. By 1842 we had our Australian Constitutions Acts. The first one was in 1842, the second in 1850, and these continued this responsible government and the expansion of Legislative Council. Okay, and now you'll find that we introduced representative government, which is another legal doctrine, in the sense that 2/3 of this Legislative Council, expanded Legislative Council, now are elected. Okay, so now we have created the system of representative government by allowing elected representatives to be part of this Legislative Council, to whom of course the government is responsible. Okay, the Act also gave the governor the power to establish district courts, and that meant that this was the beginning of the first general system of local government in Australia. Okay. By 1850, when we look at the Australian Constitutions Act of 1850, number 2, so the second Australian Constitutions Act, we find that the Act enabled these colonies of New South Wales, of Victoria, Tasmania, South Australia and Western Australia to take the next steps towards independence. How did they do that? It gave the Legislative Council or the councils of these colonies the power to create local legislatures. So now in 1850, for the first time, we created legislatures in Australia, meaning that we now create law in Australia. Okay. The Act provided the basic format for the drawing up of constitutions, and it made local government was made voluntary under the Act, and it affected basically the separation from New South Wales of the Port Phillip district, i.e. Victoria, with its own Legislative Council and Supreme Court in 1851. So we come up now to 1855 and the New South Wales Constitution Act, which was a response to demands from the colonists for greater self-rule and for local control over taxes. So the English Parliament passed this act that established a constitution for New South Wales and provided a bicameral legislation, i.e. a parliament with two houses. This parliament was empowered to make laws for the peace, order and good government of New South Wales, and the language of this act, by saying that it is an act empowering the making of such laws for the peace, order and government of a certain territory or a certain colony, that in itself meant that it had the power to raise taxes and duties. Okay, so it's an extensive power, but it wasn't clear whether this parliament could amend its own constitution or, for that matter, pass laws that were inconsistent with the English Parliament. So now we have created these parliaments which can make laws for Australia, but the question was, can they make laws for Australia that are repugnant or different or inconsistent with those in England? So that brings us to the Colonial Laws Validity Act of 1865. Okay, so this was an explicit now right given to the colonies to amend their own constitutions, saying that the colonies could enact legislation without necessarily applying English domestic law to Australian law, provided though that no English statute directly applied to the colony in question. Okay. So where an English statute contained express provisions that it had to be followed by colonial governments, it was said to have what's known as paramount force. Okay? Where an English statute contained express provisions that it had to be followed by colonial governments, it was said, i.e. this English statute is said to have paramount force, enabling the Imperial Parliament to pass laws overriding colonial laws. Okay. So English laws that were part of the received law of the colonies pursuant to the Australian Courts Acts of 1828 could be amended or repealed. Now we can take the law that we have received through the Doctrine of Reception and through the Imperial Act of 1828, the Australian Courts Act of 1828, we can take these laws and amend them or even repeal them. It's also interesting here to note that the restriction on legislative power by the Act continued all the way until the passing of the Australia Act of 1986. That was really the final breaking point where we can create our own laws without any restrictions whatsoever from England. Alright, so I will continue then with our discussion of the second objective, which says discuss the development of Australian laws. And this graph here shows us how we started, all of our current states started from English law from 1800, and English law continued beyond 1828 in places like Western Australia all the way until 1890. However, in places like New South Wales and the states that were created out of New South Wales, like Victoria, New South Wales statutes started to take effect from 1828, and of course Victoria then separated in 1850, and you can see that that continued all the way until 1901, when we had Commonwealth statutes become the law of the land for all of these states, plus of course their own statutes coming through from their own legislatures. So as we said, the Colonial Validities Act of 1865 established that the UK Parliament can override our own laws that we make here in Australia. So this was back in 1865, and this is what was known as the doctrine of repugnancy. So this is just the mirror image of what we talked about as the paramount force that's given to an English statute if it applies specifically to certain colonial government. So if there's a repugnancy between the laws passed by a certain legislature in Australia and the English laws received that applied to these, I should say the English laws that applied to this colony, and if there's inconsistency, then of course the United Kingdom Parliament can override the laws that were passed by the Australian or colonial Parliament. Okay. So in essence, back in 1865, this was a restriction on Australia's legislative powers. Then we get into the story of federation. So we are now going to the 20th century, and we find that there were a number of attempts to have federation. Okay. And the first one that was really very successful. There were previous attempts, such as the confederation that they wanted to create with even Fiji and New Zealand, but that didn't really work out. And the first one that was successful was this attempt that took place in the 1880s and in the 1890s, which invited countries like actually New Zealand and Fiji to participate at the beginning, but then they decided that they would rather have their independent status outside the Commonwealth. But there was a sequence or a series of constitutional conventions that led to the adoption of a constitutional draft, and they needed to have referenda in each one of the adopting colonies, namely in Victoria, New South Wales, South Australia and Tasmania, and Western Australia, but that's a separate story still. But these first colonies wanted to have referenda, and they voted yes on the draft and adopted the constitution. Okay. A second referendum was then held in places like Queensland, who wanted to first look at what New South Wales is going to decide, and once New South Wales adopted the constitution, Queensland followed with their own referendum and also adopted the constitution. But Western Australia, okay, refused to hold a referendum. Eventually, of course, all of these states entered into the federation, and the key point that we want to highlight here in relation to these referenda that we just mentioned is the fact that even though the majority of the voters in these colonies said yes to the constitution, we need to understand the meaning of majority back in 1900. So you'll find that voting, first of all, was not compulsory. Okay, So many people who could vote did not. But more importantly, a lot of people were not eligible. Okay, so only South Australia and Western Australia allowed women to vote in the referenda. We're talking the year 1900. Poor people, okay, in receipt of public assistance could not vote. And Queensland and Western Australia didn't allow Indigenous Australians or Asians or Africans or Pacific Islanders to vote unless they were the holders of property. Okay, so once basically this majority vote was secured, the British Parliament passed a constitution bill that was given the assent by Queen Victoria on the 9th of July of 1900, and that was the Commonwealth of Australia Constitution Act. All of this still without Western Australia's agreement. Okay, it wasn't until the 31st of July, end of that month, okay, that Western Australia agreed to hold a referendum, and a large majority voted in favor of the Federation. So now we come to the Commonwealth of Australia Constitution Act. As we said, the bill got the assent by Queen Victoria on the 9th of July 1900, but the act itself came into effect on the 1st of January 1901. And by coming into effect, it transformed the 6 independent colonies into states. So our states were not really independent states when they entered into the Commonwealth. So the Commonwealth simply transferred them from the Act of Federation, transferred them from being colonies to being states within this federal system. And under the system, which was based on the English Westminster system of government, with a bicameral parliament, so 2 houses. One of them is the lower house, the House of Representatives, and the other, the upper house, the Senate House. The Federation, or the Act of Federation, made Australia a dominion, okay, which meant that you really created a self-governing country, although the Colonial Laws Validity Act of 1865 still gave the English Parliament the power to pass any laws that it felt were necessary to protect the interests of the British Empire. Then there was the Constitution Act of 1902, okay, which established the Constitution of New South Wales, now with the power to legislate for the peace, order and good government of the state rather than the colony, and the Constitution Act Amendment of 1922 in Queensland, where the Queensland Parliament began, where the Queensland Parliament transferred from a bicameral Parliament to a unicameral Parliament, so they have only one House of Parliament, so only the lower house. Then we come to the Statute of Westminster of 1931, and this was the first legal clarification on the status and relation of Britain and the Dominions. So there were other Dominions besides Australia, like for example Canada, South Africa, New Zealand, Newfoundland and Ireland, so for Ireland, which had never been defined in law. So again, the Statute of Westminster Act of 1931, again an act by the Imperial British Parliament, wanted to establish the to clarify the legal relationship between Britain and these dominions. As we said, there were dominions such as Canada, South Africa, Australia, Newfoundland and Asia, which I understand is the Irish pronunciation for Ireland, or the Irish name for Ireland. And this act was required or was intended to define the relationship between Britain and these dominions. Under the Act, the Commonwealth Parliament gained the right, our Commonwealth Parliament gained the right to repeal or amend applicable laws passed by the Imperial Parliament. Okay, and it was stated that future statutes passed by that Parliament had no force in the Dominions, i.e. by the Imperial Parliament, unless requested by the Dominion Parliament. So unless the Dominion requests the British Parliament to pass a law for it, that law wouldn't be effective. But this of course meant that there were no more constitutional limitations such as the repugnancy doctrine that were imposed by the Colonial Laws Validity Act of 1865. So Section 2 no longer made the legislation of the colonial parliaments subordinate to acts of the British Parliament. However, this Westminster Act did not come into force until it was ratified by the Parliament of each Dominion. And in Australia, that ratification had to wait until 1942. So as you can imagine, this was all linked in one way or another to the in the context of the Second World War and the threats that were being perceived in relation to these dominions. Eventually, we made a retrospective adoption of the Act under the Statute of Westminster Adoption Act of 1942, and that was retrospective back to 3rd of September 1939. Again, this is something that doesn't usually happen. If you go back and we look at or remember our characteristics of legal systems, retrospective legislation would be unfair, but in this case of course there was an exception, and they made that act retrospective to the 3rd of September 1939 because we were going through the outbreak of the Second World War. Okay. So this act basically now with its adoption removed the final limitation on self-government. Now the Commonwealth, but not the states, the Commonwealth Parliament could amend or repeal any English law. Okay. The position of the states was that they were left to relate directly to the British Parliament on certain issues and vice versa. So it was only the Commonwealth Parliament that could pass legislation to the effect of amending or repealing English law, but the states had to wait until 1986 to get that right of amending and repealing. But then let's then move to the Privy Council Limitation of Appeals Act of 1968, and this basically abolished the right to appeal to the Privy Council from the High Court of Australia on matters involving federal law. So if it's something that has to do with federal law, i.e. with the Commonwealth, it will stop with the High Court. You cannot go to the Privy Council and appeal the decision from the High Court. However, it was still possible for a litigant to appeal from a state Supreme Court or the High Court on matters of state law. So even if it's the High Court adjudicating on a matter, if that matter was an act of Parliament of one of the states that got appealed to the High Court, then it could still continue its appeal all the way to the Privy Council. Later, of course, there was the Privy Council Appeals from the High Court Act of 1975, which removed the right of appeal from the High Court of Australia to the Privy Council, but it was possible still for litigants to appeal from a state Supreme Court to the Privy Council on questions of state law until, of course, 1986. So with this Act of 1975, you couldn't appeal anything from the High Court, regardless of whether it was federal law or state law. If it comes to the federal law, then that's the end of it. But you could still appeal directly from a state Supreme Court to the Privy Council if it was a question of state law. That was taken away as well with the passing of the Australia Request and Consent Act of 1985 and the Australia Act of 1986. And these acts repealed basically the power of British Parliament to make laws binding on the states under the Colonial Law Validity Act of 1865. In particular, they abolished what was known as the repugnancy rule, whereby a state law that was inconsistent with an English law was invalid. Okay. The legislation abolished the right of appeal on questions of state law to the Privy Council from the state Supreme Courts. Alright. Let's then continue. So we just finished talking about the referendums that were held after the Constitutional Conventions of 1891 to 1898, and we talked about how these led eventually to the adoption of the federal system in Australia. The third objective is to explain the significance and structure of the federal constitutional system, and that comes of course from the Commonwealth Constitution Act of 1900. This is of course the Commonwealth of Australia Constitution Act 1900 is a larger act than just the constitution that you see on this slide. This constitution is found under clause 9 of that constitution, of that act, of the 1900 Act. So the constitution has these 8 chapters, and I'm not going to go into much detail into each chapter and what it represents. I'll leave that to you to have a look at. And the key point I want to establish here, so you can have a look at that from page 32. What I want to talk about is this. So this Australian Constitution, the Commonwealth Constitution, established 3 different types of powers, some of which are exclusive to the Commonwealth. So only the Commonwealth can deal with these powers and pass legislation on these powers. And you find a list of these powers on this slide, left hand side. There are also powers that are exclusive to the states, what we call residual powers. And examples of these are education and local government and transport. For example, section 107 is the saving section in the Constitution as far as these powers are concerned, what's known as, again, residual or residual powers. And the last and most interesting design of our Commonwealth Constitution is the concurrent powers, or shared powers, that we find in section 51. This is an innovation in constitutional design that you don't find in the constitutions of, for example, the United States, the other 2 great Anglo-American federations, the United States or Canada. In fact, in Canada there are only 2 or 3 concurrent powers between the federal government and the provincial governments of Canada. But our design has 40 heads of concurrent powers between the Commonwealth and the states, and that's an innovation of its time back in the 1900 and 1901. And it provided this flexibility or agility of the federal system in Australia, where these powers could be sort of transferred between the Commonwealth and the states. Alright. So again, this is the idea of this vertical division of powers under the Constitution, the idea of exclusive, concurrent and residual powers, and the importance, of course, of the fact that there was inconsistency between the laws of the Commonwealth and the states. Okay, it's the Commonwealth law that basically trumps. And of course the Constitution talks about the Parliament and the legislative branch and the executive branch, including the High Court, or what we call Section 71 courts. Okay. And also talks about the way that the Constitution could be changed. Now, a very important point about how the Constitution could be changed is that we are also different from the United States and Canada in that we require referenda and double majorities. So you need actually to get the majority in each state and the majority of all the voters in order for you to change the Constitution, which comes under Section 128. And you will find on pages 34 and 35 of your textbook a list of the heads of powers under Section 51, the 40 heads of powers. Now, one thing we need to remember here is that the whole Constitution is available for you online for free. So you can go through all the sections as much as interests you. But for our purposes, because this is again a business law course, we want to just emphasize the vertical division of powers and the fact that there are these concurrent powers, because they will become an important part of what we will talk about as far as the development of law in Australia. For example, things like the passing of corporations law and so on, but that's going to come in later lectures. Alright, let's then proceed to our last objective for today, which defines the doctrine of the separation of powers. We are required to define the doctrine and discuss its theoretical and practical functions. So again, because it's a doctrine, that means it started basically as a principle, in the sense that it started as a legal theory after a French jurist by the name of Montesquieu, and it was adopted basically by the court system, and it became the doctrine of separation of powers. And it says basically that there is a horizontal division of powers under the Commonwealth Constitution. So we just talked about the vertical division and the separation of powers between the Commonwealth and the states and the concurrent powers, but there's also a horizontal separation between the Commonwealth Parliament, the Commonwealth Executive, and the Commonwealth Courts. So each one of these branches is said to have its own sphere of power, and they act as checks and balances on each other. Okay. Under the doctrine, the legislature, i.e. the Parliament, okay, these are the people who enact or make the law, they are the supreme lawmaker, and the other two branches, the executive, is basically to administer, okay, or formulate policy under this law enacted by the legislature, while the judiciary has simply the function of enforcing, interpreting, applying and enforcing the law that was made by the legislature. In theory, this doctrine means that no one person or body shall exercise more than one power, which is a limitation on the powers of the Commonwealth Parliament. In essence, however, the doctrine is based on the idea of checks and balances. In reality, there is no separation in Australia and in any system under the Westminster system of Parliament. There is no separation between the executive and the legislative branches, because the Prime Minister and the executive ministers must be elected members of Parliament, which is the arm that exercises the legislative function. So executive power generally rests with those ministers in government who form the cabinet. But in other jurisdictions, like an example in the United States, we see a more explicit separation between the legislature, which is the Congress, and the Congress there is the Parliament, so it has the House of Representatives and the Senate, and the executive, which is basically the President and the Secretaries of State. So that's one thing to remember in relation to how this doctrine applies in a place like Australia compared to a place like the United States, where in Australia separation of powers between the executive and the legislative branches is non-existent because they are both one and the same. All the executive is members of the Parliament, and the separation of powers in places like the United States, where that is not true, where you find that there's a separation between the members of Congress and the members of the executive. Alright, we'll leave it then there in relation to this doctrine. We said already that in reality there's no separation between the executive and the legislature in Australia, and then that brings us to the end of our lecture on this chapter, chapter 2. Our next lecture is gonna be on chapter 3 and the legal systems, and a further discussion of legal systems in the Australian context. Thank you.